I'm Abby, and today I'm here with Lem Garcia from Lem Garcia Law. Good to have you back, Lem. Thanks for being here.
Oh, great to be here.
Today, we are clearing up one of the biggest misunderstandings drivers in West Covina have after a crash, the belief that California is a no fault state. It is not, and almost everything you can recover turns on that one fact. We are going to break down what fault actually means, how California's pure comparative negligence rule works, how fault gets decided after a wreck on the I 10, I 605, or the SR 60, how insurance companies use a little bit of shared blame to cut your check, and the deadlines that decide whether you have a case at all. If you have been in a crash in West Covina or anywhere in Los Angeles County, this episode is for you. Almost everyone repeats the no fault line, and it shapes every decision that they make after a crash. To start us off, a lot of drivers here in West Covina assume California is a no fault state. Is that actually true?
No, California is actually not a no fault state. And honestly, that's a misconception that I hear quite often. In no fault states, people often start by going through their own insurance for certain injury benefits, regardless of who caused the crash. California does not work that way. In California, fault matters because the person who caused the accident is generally responsible for the damage that they caused. So let's say you're sitting at a red light and somebody rear ends you. We're going to look at who caused the crash because that's going to affect who pays it. And fault isn't always 100% or zero. Maybe the other driver ran a stop sign, but you were speeding. Maybe they're 80% responsible and you're 20% responsible. In that situation, they're responsible for 80% of the damages and you're responsible for 20%. And that's why these cases often become fights over who's at fault. Every percentage point matters. And that's the biggest thing to remember. California is not a no-fault state. In California, one of the first questions we ask after a crash is, who caused it? Because that answer to that question affects everything that comes next.
People use the word fault loosely, but in a claim, it has a specific legal meaning. So, if California is a fault state, what does fault actually mean in a car accident claim?
Fault is just legal blame. After an accident, we're trying to answer a simple question. Who caused the crash? Because in California, the person who caused the accident is generally responsible for the damage that follows from that accident. And sometimes that's easy. If a driver is looking at their phone and rear ends a car stopped at a red light, most people would say that the driver is to blame. And the law usually would agree with that. But not every accident is that simple. So let's say one driver runs a stop sign, but the other driver is speeding. Now we're not arguing about whether someone is to blame. We're arguing about how much blame belongs to each driver. And that's what fault really is. It's figuring out who made the mistakes that led to the crash and assigning responsibility for those mistakes. And in California, that responsibility determines who pays for the damage. And that's why fault is the foundation of every car accident case.
This is the rule that quietly controls how much money actually changes hands. Can you break down California's pure comparative negligence rule in plain English?
Sure. Here's something that most people don't know. You can be mostly at fault for an accident and still have a case. And that's because California follows a rule called pure comparative negligence. The legal term isn't important, the idea behind it is. So, if you're partly to blame for an accident, your recovery gets reduced by your share of the blame. It doesn't automatically disappear. For example, if you're 20% at fault, you're responsible for 20% of the damages. If your damages are worth $100,000, you can recover the remaining 80%. But here's where people get surprised. So let's say you're 90% at fault and the other driver is only 10% at fault. Most people assume the case is over, but not necessarily. The other driver can still be responsible for their 10% share of the damages. If you've suffered a serious injury, that 10% can still be a meaningful amount of money. I've had people call my office convinced that they didn't have a case because they made a mistake. What they didn't realize is that California doesn't ask whether you were perfect. It asks how much blame belongs to each person. So keep this in mind. Fault reduces a claim. It does not automatically eliminate it. And that's why one of the biggest mistakes people make is assuming they're out of luck just because they were partly responsible for the crash.
This is the part that stops people cold because it sounds too good to be true. Here's the one that surprises people. Can I still recover money then if I was 99% at fault for the crash?
Yeah, believe it or not, the answer is yes. You can still recover money, even a good amount of money, if you were 99% at fault for the crash. And when people hear that for the first time, they usually think there's no way that can be true. But that's how California law works. If you're 99% at fault, you're responsible for 99% of the damages, but the other driver is still responsible for their 1%. Now, that doesn't mean every 99% fault case is worth pursuing. Sometimes that 1% may not amount to much, but sometimes it matters a lot. We've handled cases where our client was mostly at fault, but the other party still shared a small percentage of the blame. And because our client suffered serious injuries, that small percentage still resulted in a substantial recovery. In some cases, or in one case, even over $1 million. And I think that's the part people miss. They get so focused on the percentage of fault that they forget about the size of the damages. A small percentage of a very large case can still be a very large case. I've had people call my office convinced that they didn't have a case because they made a mistake. But the reality is that being mostly at fault and having no case are two very different things. The biggest mistake people make is talking themselves out of a case. So the lesson here is simple. Don't count yourself out. In California, thankfully, mostly at fault does not mean out of luck.
A lot of people have heard a rule from another state and assume it applies here. So, how is California different from these states that cut you off if you're more than half at fault?
Here's what makes California different. In some states, if you're more than 50% at fault, you recover nothing. And think about that for a second. You could be 51% at fault, suffer a serious injury, and still walk away with nothing because you crossed that line. And thankfully, California does not work that way. California follows what's called pure comparative negligence, which means that there is no percentage of fault that automatically wipes out your claim. If you're 20% at fault, your recovery is reduced by 20%. If you're 60% at fault, your recovery is reduced by 60%. The claim gets reduced, but it doesn't automatically disappear. And that's a huge difference. People call my office and they think they don't have a case. But again, they realize that California doesn't care whether you're 49% at fault or 90% at fault. The question is how much damage was caused and what percentage of that damage each person is responsible for.
So, the headline is that California is a fault state with a forgiving pure comparative rule. Now, let's get into how fault actually gets decided after a wreck out here. So, people picture fault being settled at the scene, but it is more of a process than a moment. Walk us through how fault actually gets decided after a wreck here in West Covina, say on one of our San Gabriel Valley freeways like the 10 or the 60.
One of the biggest misconceptions people have is that fault gets decided at the scene of the accident, and it doesn't. Just because the driver says, it wasn't my fault or it was my fault, that doesn't mean the case is over. On freeways like you mentioned, the 10, 60, or the 605, the CHP, the California Highway Patrol, will usually respond, investigate the collision and make a police report. And that report is really important, but it's just really the starting point of the investigation and not the finish line. And then after that, everyone starts gathering evidence. The insurance companies look at the police report, the witness statements, photographs, video footage, vehicle damage, and sometimes even accident reconstruction experts if the case is serious enough. Think about a disputed lane change accident. Driver A says driver B drifted into their lane, and then driver B says exactly opposite. And then standing on the shoulder of the freeway, nobody really knows who's right. And that's where evidence comes in. The fault is determined by who tells a better story. It's determined by who can prove it. We've seen cases where a single witness changed everything. We've seen dash cam footage completely flip a case that looked like it was unwinnable at first. So that's why I tell people, don't panic if the facts aren't clear at first. The scene of the accident is really where the investigation starts, but it's not where fault gets finalized.
People treat the police report like a final verdict on who pays. If the California Highway Patrol writes that the other driver was at fault, does that settle it?
The police report is important, but it's not the final word. We've seen cases where the police report got it exactly right. And then we've also seen cases where evidence that surfaced later just changed the entire picture. The reality is that the CHP officer, they weren't there when the crash happened. They got there afterward, talked to the drivers, talked to witnesses, and then they looked at the vehicles, and then they just did their best to figure out what happened. Most of the time, they do a very good job, but still, a police report, it's just one piece of the evidence. Let's say the officer concludes that driver A caused the crash, and then a week later, dash cam footage surfaces showing something completely different, or there's a witness comes forward who wasn't interviewed at this scene. Now we're looking at information that the officer never had. We've seen 30-second videos do more to determine fault than the full report. And that's why insurance companies, lawyers, and juries, they don't stop at the police report. They look at all of the evidence. The police reports, again, just starts the investigation, but it doesn't finish it. It just helps tell the story. The evidence ultimately determines whether it's the right story or not.
And whether the crash is on a freeway or a city street changes who even shows up. For a crash on West Covina surface streets, who shows up and writes the report? And does that change anything?
Whether it's West Covina or the freeway, the badge might change, but that's about it. The job doesn't change. If the accident happens on a West Covina city street, it's usually the West Covina PD that responds and prepares a report. If it happens on the 10, the 60, 605, name another freeway, it's usually the CHP. And then if you're looking at the unincorporated areas, it might be the LA County Sheriff's Department. But regardless of what agency it is, they're all trying to do the same thing. Figure out what happened, document the evidence, talk to the people involved, and really just create a record of the collision. What mattered isn't necessarily who wrote the report. What matters is whether the report accurately captures what happened. A good report is helpful whether it comes from the CHP, West Covina PD, or the Sheriff's Department. Again, the police report is important, but it's only one piece of the evidence.
The classic problem is two drivers with two completely different versions of events. What evidence actually proves who was at fault when the two drivers tell completely different stories?
When the stories conflict, the evidence usually wins. Almost every driver thinks they're right. I've never had a client walk into the office and say, hey, let me tell you all the reasons why I was at fault for what happened. And then when two drivers tell completely different stories, we have to start looking beyond what people say and really focus on what we can prove. And that's where evidence becomes incredibly important. Dash cam footage can be powerful. Surveillance video from a nearby business can be just as powerful. And of course, witnesses. Witnesses are crucial. There's been cases where we have two drivers argued for months about what happened, and then later on we get a 30-second video about what happened, and that settled it immediately. And sometimes the physical evidence tells the story. The damage to the vehicles, the location of the impact, skid marks, debris. In serious cases, that's where we would get an accident reconstruction expert so that we can really use the evidence to determine how the collision occurred. And the best evidence doesn't have a memory. It doesn't get nervous, doesn't forget details, and that's why we're looking for photographs, videos, even independent witnesses are very important. Fault is determined by who can prove what happened.
People assume the kind of collision automatically decides who is to blame. So, does the type of crash itself, like a rear end versus a T-bone, change who's presumed at fault?
Sometimes the type of crash gives you a pretty good clue, but it's not the whole answer. Take, for example, a rear end collision. If you're stopped at a red light, somebody crashes into the back of your car, that's usually a strong indication that the driver in the rear is at fault. Most people would look at that situation and say, of course they're at fault. And most of the time they'd be right, but not every rear end crash is automatic. What if someone suddenly backs up into the vehicle behind them and crashes into them? What if someone cuts someone off and slams on their brakes? Then the analysis of the accident gets more complicated. And the same thing with T-bone accidents. When one vehicle strikes the side of another, the first question is usually who had the right of way? Did someone run a red light? Did someone ignore a stop sign? Did someone make a left turn in front of oncoming traffic? And that's where the answer is found. The type of crash can point you in the right direction, but it doesn't always tell the whole story. The damage tells just part of the story, but again, the evidence tells the full story.
When the other driver was clearly reckless, people assume fault is a foregone conclusion. What about the driver who's clearly the cause, like the distracted or drunk driver who blows through a West Covina intersection? Does that lock in fault?
A drunk driver or distracted driver can make fault a whole lot easier to prove. But let's be honest, if someone blows through a red light while drunk and crashes into my client's vehicle, I'm probably going to be arguing that the driver is 100% responsible for the accident. And in many cases, that's exactly where the evidence leads us. And the same is true for distracted driving. If someone is looking at their phone instead of the road and causes a crash, that's powerful evidence of fault. Phone records, witness statements, surveillance footage, police reports, and even citations can all help tell that story. But here's where we still investigate every case. The law doesn't just look at whether someone was drunk or distracted. It looks at what role each driver's actions played in causing that collision. Let's say a drunk driver runs a red light and crashes into another vehicle. That's terrible for the drunk driver. But what if the other driver was racing through the intersection at twice the speed limit? Now we may have a discussion about whether both drivers contributed to what happened. Strong evidence of fault is not the same as automatic fault. Most of the time, the drunk or distracted driver is going to bear the overwhelming majority of the responsibility, and sometimes all of it. And that's where advocacy comes in. Our job is to gather the evidence, develop the facts, and present the strongest possible case for our client. And the insurance company is going to use the evidence in the light that's most favorable to them. That's how cases are won. At the end of the day, we're not just asking what happened. We're asking what can be proven and how do we use those facts to achieve the best possible result for our client.
And here's where it gets practical. How does an insurance adjuster use that little bit of shared fault to cut down what they offer a West Covina driver?
So this is important. Every percentage point of fault has a dollar value attached to it. And that's why insurance companies spend so much time arguing about who's at fault for what happened. Let's say your case is worth $100,000. If they can convince a jury, an arbitrator, or even you that you're 20% at fault, they've potentially reduced the value of the claim by $20,000. That's real money. And that's why fault isn't just a legal issue. It's really a financial issue. I've had clients tell me, oh, the adjuster said I should have reacted faster, or the adjuster said I could have avoided the accident. That's not a coincidence. The insurance company is always looking at whether some portion of the blame can be shifted to you, because every percentage point they move in their favor can reduce what they have to pay. And that doesn't mean they're wrong. Sometimes people do share responsibility for the accident, but it doesn't mean you should understand what's happening. When fault goes up, compensation goes down. And that's the game that they're playing. And this is where our advocacy matters. The insurance company is going to use facts and evidence in the light most favorable to them, and we use the facts and evidence in the light most favorable to our client.
And then the adjuster calls and asks for a quick recorded statement, sounding maybe friendly about it. But what is the trap with giving a recorded statement? And can it come back to bite me on fault?
The recorded statement is usually not for your benefit. It's for the insurance company's benefit. A lot of people think, they're just helping move the claim along. They get a call from the insurance company, answer a few questions, and assume it's just part of the process. The problem is that you're often being asked to give a detailed statement before all the facts are even known. You may not have seen the police report yet, or you may not know what the witnesses said. You might not have seen the video footage, and sometimes you don't even know the full extent of what your injuries are. And then the insurance company starts asking questions. Oh, how fast were you going? Could you have avoided the accident? When did you first see the vehicle? How injured are you? These sound like innocent questions, but most of the time they're not. And you have to keep in mind that just one careless answer can really become a carefully crafted argument for the insurance company later. We've seen people, they just try to be honest, cooperative, and helpful, only later to have a statement used against them months later to argue that they were partly at fault for what happened. And that's why generally we don't recommend giving a recorded statement to the other driver's insurance company. The insurance company is not taking a recorded statement to help your case. The insurance company is gathering evidence to hurt your case. And you have to keep in mind that you only get one chance to give your version of events when you're being recorded. So you have to make sure that it's accurate, complete, and given really at the right time. So because once the recording starts, you're creating evidence, and that evidence can either help you or it can hurt you.
People want to see how the fault percentage turns into real dollars. Once fault is figured out, how does my percentage of blame actually change the dollar amount I get?
Fault affects value, but fault isn't the only thing that affects value. So again, let's say your damages are $100,000 and you're found to be 20% at fault. Your recovery would be reduced by 20%, meaning you could recover $80,000. That's just basic math. The reason why insurance companies fight so hard over fault is because, again, every percentage point can reduce what they have to pay you. When fault goes up, compensation goes down. But here's something I think a lot of people may not realize. Just because an insurance company assigns some fault doesn't mean we're automatically worried about the case. And why? Because fault is only one part of the equation. The other part is damages. We've handled cases where the insurance company argued our client shared some responsibility for the accident. And that's not unusual. And the real question becomes, even after accounting for that fault, is this case still worth more than the available insurance coverage? And a lot of times the answer is yes. In fact, there are cases where faults are being disputed and the injuries are so significant that the value of the case still exceeds the insurance policy limits. And then at that point, the fight isn't necessarily about whether the client's 10% at fault or 20% at fault. The fight is often about getting the insurance company to recognize the true value of the injuries. Fault matters, but damages matter too. And when serious injuries are involved, the size of the damages can become every bit as important as a percentage of fault. And that's why we don't just ask who's to blame. We also ask, what is the case actually worth?
Yeah, people hear damages and they may think that it's just the car and the medical bills, but what kind of damages are even on the table in a California injury claim?
So there are really two categories of damages in injury cases. You have special damages and general damages. Special damages, those are usually the easier ones to understand. The financial losses, medical bills, lost wages, future medical treatment, future lost earnings. Those are the damages that can usually be calculated. You can put a number on it easily. General damages are very different. General damages, they're about how has the injury affected your life. And honestly, that's where some of the most important damages are found. The jury instructions, they talk about things like physical pain, mental suffering, emotional distress, physical impairment, disfigurement, inconvenience, grief, anxiety, humiliation, and I think a key one, loss of enjoyment of life. And that's the legal language, but the real question, to make it easier to understand, how has this injury changed your life? Think about, is it hard to get ready in the morning? Can you no longer exercise like you used to? Can you not pick up your kids like you did before? Have you gained weight because you're less active? Did you give up hobbies that you were passionate about? And those losses are the ones that matter a lot. In serious injury cases, and I think that's the real loss. And that's why I always want to know, or our office wants to know, about the client's life. Because if we don't understand who you were before the accident, it's really difficult to explain what the accident took away from you. The true value of a case isn't just found in the medical bills. It's found in the difference between the life you had before the crash and the life you have after it. That's the story we're trying to tell.
It is a gut punch to learn that the person who hit you may have carried almost nothing. So let's talk insurance reality. What if the at fault driver doesn't have enough coverage to pay for what they caused?
This is one of the most difficult conversations that I have to have with clients. Sometimes a person suffers a very serious injury, and the case might be worth far more than the available insurance coverage. And no matter how clear the fault is, no matter how serious the injury is, and no matter how much damage has been done, there's just not enough insurance coverage available to really fully compensate our client, the person that was hurt. And then that's a really difficult reality for people to accept. I often sit across from clients, their lives were changed by a crash and their lives were turned upside down. They can't work the same way. They can't enjoy life the same way. They can't do the things that they used to do. Yet the insurance coverage available might only be a fraction of what the case is actually worth. So then the next question that we often get is, why don't we just sue the driver? Sometimes we can, but far often than not, it's not worth to pursue the driver. People need to understand that getting a judgment against a defendant is not the same thing as actually getting money from them. You can spend years and years fighting a lawsuit, win a judgment, and still find yourself trying to collect from the defendant, from someone who they just don't have the money to pay for it. Clients need to keep in mind that going to court does not automatically create more money for you. In fact, if there's no additional source of recovery, litigation or going to court can sometimes ultimately reduce what the clients end up with in their pocket, because unfortunately, litigation costs a lot of money. Experts, depositions, lawsuits, all that costs a lot of money. And that's why it's our job not just to figure out what the case is worth, it's really to figure out how to put the most money possible into our client's pocket. The goal isn't just to win the biggest judgment. The goal is to maximize the client's recovery. And on a different point, that's why it's really important to carry uninsured motorist coverage, underinsured motorist coverage, because when the person who causes the crash doesn't have enough insurance, your or UIM coverage steps in and protects you and it pays you for your claim. I think it's one of the most important coverages you can buy, because you can't control who hits you, but you can control whether you're protected when they do.
So the insurer's whole game is to push your fault up and your coverage knowledge down. Let's close on injuries, deadlines, and what happens if a fault fight has to go to court. So people underestimate how much their treatment paper trail decides the case. Why do medical records matter so much when the other side is trying to pin fault on me?
This is what I tell clients all the time. The insurance company, they don't just pay for injuries. The insurance company pays for documented injuries. And that's the difference. That's why medical records are so important. Even when the insurance company, they're arguing that you share some fault for the accident, they still have to evaluate the harm that was caused. And the medical records are often the most important evidence of that harm. They document your symptoms, diagnoses, treatment, recovery, and sometimes the fact that you're not ever fully recovered. It really creates a timeline showing what happened after the crash and how the injury affected you over time. Medical records are only as good as the information they contain. The doctor can't document what the doctor doesn't know. So you have to express it: pain, limitations, sleep issues, and other symptoms. So you need to discuss those with your providers so that the record can really accurately reflect what you're experiencing. And that's what we found, that a lot of people focus on where it hurts. And that's important. But some of the most important parts of a case really have nothing to do with a diagnosis. An injury might make it hard to get ready in the morning. A person who used to be active may stop exercising. Someone who loves sports, travel, or playing with their kids might no longer be able to enjoy those same things in the same way. And the medical records tell us what the injury is, but your story tells us what the injury, again, took away. And that's why we spend so much time learning about our clients' lives, because the true impact of an injury is often found in the difference between life before the crash and life after it. We're not just trying to prove that you were injured. We're trying to show how the injury changed your life.
Most people have no idea there is a hard clock running from the day of the crash. What is the deadline to actually file a case in California, and what statute sets it?
In most California personal injury cases, you have 2 years from the date of the accident to file a lawsuit. And if you miss that deadline, you may lose your right to pursue compensation altogether. And that's why this is not something that you want to put on the back burner. A lot of people hear 2 years and they assume they have plenty of time, then life happens, they're focused on treatment, work, family obligations, and just really trying to get back to normal. And then before they know it, months or even years have passed. And the deadline isn't really the only concern. Evidence gets worse with time, witnesses become harder to find, memories fade, video footage gets deleted. The sooner a case is investigated, the better the chance of preserving important evidence. I've seen people wait because they thought the insurance company would just eventually do the right thing. Others assume they could just always deal with it later. That's really a risky approach. When it comes to the statute of limitations, if you mess around, you're going to find out. And you don't want to find out that you just lost a case that could have been worth a lot of money. By the time people discover they've missed the deadline, it's already too late. And the takeaway here is, I think, simple. Don't wait to learn your rights. 2 years sounds like a long time until it isn't.
And there is an exception that catches people completely off guard too. Are there situations where that 2-year clock runs out faster, like a crash involving a government vehicle or certain road defects?
Just because you have 2 years in one case doesn't mean you have 2 years in every case. And that's especially true when a government entity may be involved. If you're injured by a government vehicle, a dangerous roadway, a defective intersection, or just another condition involving a public entity, you may only have 6 months to file a governmental claim. And that's not a lawsuit. It's a special claim that generally must be filed before you can pursue a lawsuit. And if you miss that deadline, you could lose your rights to recover altogether. And I think what makes those cases really tricky is that their rules have to be followed very carefully. Government agencies, they often require specific claim forms. The claim must be sent to the correct agency. And I think it's a good idea to send that via certified mail so you can prove it, that it was submitted and received by them. When it comes to government claims, close enough is a lot of times not good enough. And again, filing the claim is really only the beginning. Once the government responds, there's more deadlines and procedures that will apply. And that's why when clients say, or potential clients say they want to handle the government claim on their own, I get really nervous. They're focused on medical treatment and getting their life together while we have these important deadlines that are quietly approaching. Not every injury case comes with the same deadline, but when a government entity may be involved, it's really best to get an attorney involved as soon as possible.
And when the offer is unfair, people want to know where this actually goes. So, if a fault dispute can't settle, where does a West Covina car accident case actually get filed and heard?
Most car accident cases, they never see the inside of a courtroom. They settle. But if the insurance company, they won't make a fair offer, sometimes a lawsuit becomes necessary. And if you're asking for a West Covina accident, this case will usually be filed at the Los Angeles County Superior Court. Exactly which courthouse, that depends on different factors, where the accident happened, where the parties live, and where the case ultimately gets assigned. And then once the lawsuit is filed, people need to keep in mind the case doesn't immediately go to trial. Sometimes people are surprised by that. There's usually a very lengthy process where both sides exchange information, gather evidence, take depositions, and really investigate the case further. And during that process, a lot of cases settle. We've had a lot of cases, they settle shortly before filing, during litigation, at mediation. Filing a lawsuit doesn't mean you're going to trial. It means that you're just preserving the option to go to trial. And that's really a very important distinction. Sometimes the insurance company doesn't take a case seriously until a lawsuit is filed. Sometimes they do. Every case is really different. And what I tell clients is that a lawsuit is not the goal. The goal is a fair result. If that happens before filing suit, that's great. If it happens during litigation, that's great too. At the end of the day, we're not trying to win a courtroom battle. We're trying to get the best possible outcome for our client.
That covers the myth, the rule, how fault gets decided, and how it plays out all the way to a courtroom. Let's leave folks with the one thing to remember and how to reach you. So, Lem, if a West Covina driver remembers just one thing about fault after a crash, what should it be?
That fault is determined by the evidence that you have. So it's really important to gather all the evidence you can early on and to get an attorney involved very early on so that we can do the best job possible to gather the evidence to prove your case.
The bottom line is that California is a fault state with a pure comparative negligence rule, so even partial fault does not end your claim. But the insurance company will work to push your share up, and the clock is always running. So if you have been hurt in a crash anywhere in the San Gabriel Valley, call Lem Garcia and the team at Lem Garcia Law at 626 337 1111 or reach out anytime at lemgarcialaw.com. Thanks for listening to Car Accident Playbook. We will see you on the next episode.